Welcome to the Workplace Violence and Workplace Harassment Awareness e-module. This module is intended to raise awareness and educate employees regarding the important issues of violence and harassment in the workplace. The Board is committed to maintaining a workplace that is free of violence and harassment while meeting all legislative requirements. This module will cover an introduction to workplace violence and harassment and its impact, the applicable legislation and its requirements, workplace violence and harassment definitions, types, and risk factors, and board protocols for reporting and investigating violent and harassment incidents and complaints. Violence and harassment are serious issues and affect us all. For victims of workplace violence and harassment, there are serious consequences, including high emotional trauma, stress, and possibility of physical injuries. Workplace violence and harassment can result in increased absenteeism, lost productivity, high employee turnover, and high workplace safety and insurance board costs for the employer. According to a Statistics Canada report from December 2018, 19% of women and 13% of men reported that they had experienced harassment in their workplace in the past year. Workplace harassment includes verbal abuse, humiliating behavior, threats to persons, physical violence, and unwanted sexual attention or sexual harassment. In 2017, there were 1,732, 12%, allowed WSIB lost time claims from assaults, violent acts, harassment, and acts of war or terrorism among Schedule II employers. And from 2015-2016, the Ministry of Labor issued 4,756 orders related to workplace violence and harassment, or approximately 4% of all orders issued to workplaces. Many of us have too often heard of violent incidents occurring at schools. Shootings at Columbine High School in Colorado, Dawson College in Montreal, and more recently, Marjorie Stoneman Douglas High School in Parkland, Florida, have received media attention due to their horrific nature. Even the Peel Board has its own tragedy. On the morning of December 10, 2004, a secondary school teacher at Bramalea Secondary School was murdered by her ex-husband in the school parking lot. Therefore, it is important for us all to recognize workplace violence and its risk factors and to take action to prevent its occurrence. The Occupational Health and Safety Act was amended to protect workers from all forms of workplace violence in 2010. The Act now has legal definitions of workplace violence, workplace harassment, and workplace sexual harassment, as well as provisions for employers to create policies and programs to prevent occurrences of violence and harassment in the workplace. The Act establishes minimum standards regarding an employer's duties with respect to violence and harassment at the workplace. It requires that all employers develop a policy for workplace violence and harassment, conduct workplace violence risk assessments, and have a program developed to educate and train staff. The Act also requires employers to address domestic violence when it enters the workplace. The Act also extends the work refusal process to include violence as grounds to refuse unsafe work. The Board is committed to providing a safe and healthy workplace free from actual, attempted, or threatened violence and harassment. PDSB's Occupational Health and Safety Policy, Policy Number 56, incorporates our policy against workplace violence and harassment. Specifically, the Board commits to provide an environment free of negative factors, including workplace violence and harassment. The commitment to a healthy and safe workplace that is free of violence and harassment is also supported by other Board policies, including safe schools, human rights, and special education. All Peel employees are responsible for adhering to these policies and working together to prevent workplace violence and harassment. Workplace violence and workplace harassment programs should include how to report incidents of workplace violence and harassment, how the employer will investigate and deal with incidents or complaints, how to summon for immediate assistance when workplace violence occurs or is likely to occur, and how to control for risks identified in assessments. The Peel Board has established programs to address workplace violence and harassment. Operating Procedure EHS 4.1 is the Board's workplace violence operating procedure. Similarly, EHS 4.2, the board's Workplace Harassment Operating Procedure, outlines the program for harassment-related issues. Both of these procedures are available on the intranet under Health and Safety. Recognizing a workplace hazard, such as violence, is the first step in overcoming it. Risk assessments are a process of evaluating an identified hazard to determine its probability and severity. A risk assessment includes identifying the potential risks of violence in the workplace, identifying existing controls that are in place to reduce or eliminate risks, and identifying any gaps or recommendations that are needed to further reduce or eliminate risks of violence. The Occupational Health and Safety Act requires employers to complete risk assessments for workplace violence. The board has ensured that workplace violence risk assessments were completed at all locations. Sites were required to complete an assessment to determine activities or situations that present a risk for workplace violence and ensure that appropriate safety precautions were available at each site to mitigate any identified risks. Sites may need to reassess risks of violence depending on specific factors, as outlined in the Workplace Violence Operating Procedure. Evaluating and controlling risk is an ongoing process. Let's discuss the board's Workplace Operating Procedure in more detail. The Occupational Health and Safety Act defines workplace violence as A. The exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker. B. An attempt to exercise physical force against a worker in a workplace that could cause physical injury to the worker, and C. A statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force against the worker in a workplace that could cause physical injury to the worker. Let's pause and think for a moment. What types of behaviors do you consider to be workplace violence? Think of a few examples that you consider to be violence in the workplace. Examples of workplace violence include verbally threatening to attack a worker, leaving threatening notes or sending threatening notes or emails to another worker, shaking a fist in a worker's face, wielding a weapon at work, hitting or trying to hit a worker, throwing an object at a worker, sexual violence against a worker, kicking an object the worker is standing on, and trying to run down a worker using a vehicle or equipment. It should be noted that physical contact as a result of an accident would not be considered workplace violence. Workplace violence can be instigated by any of the following. An external perpetrator. This could be a criminal who is at the workplace for the purposes of committing a crime. Non-employees or third parties. In a school setting, this could be students, parents, community members, and contractors. Fellow worker. This could be a current or former employee. External personal relationship. This is someone who has a personal relationship with a worker. As per the Act, this would be classified as domestic violence. The Occupational Health and Safety Act includes provisions for the employer to protect workers from domestic violence that can potentially occur in the workplace. The Ontario Ministry of Labour describes workplace domestic violence as a person who has a personal relationship with a worker who may physically harm or attempt or threaten to physically harm that worker at work. Personal relationships can include a current or former spouse, a current or former intimate partner, or a family member. How might you become aware of domestic violence that may enter the workplace? Some of the more common ways that coworkers or supervisors become aware of domestic violence cases are: the employee receives threatening emails and phone calls at the workplace. An incident involving an employee's spouse or partner occurs at the workplace. A concern of domestic violence is reported by the employee, and an employee's spouse or partner pays unwelcome visits at the workplace. You have the responsibility to inform your supervisor if you or a coworker is subject to domestic violence that could expose you or your fellow workers to physical injury in the workplace. The supervisor will treat the report in confidence and will only disclose information to others, such as the board's Health and Safety Department, Security and Risk Management Department, or local community police officers who can assist in putting together an action plan to protect workers at the site. In all cases, the Health and Safety Department will lead the development of a safety plan for staff to protect them from domestic violence in the workplace. There are factors or circumstances that have the potential to increase the risk of violence at a workplace for school board employees. These include, but are not limited to, protecting or securing valuables, working in a mobile workplace such as a vehicle, working off-board property, working with students with a history of violence or violent behaviors, working in high crime areas, working alone or with just a few people, and working late at night or during early morning hours. Let's talk about how you can reduce, control, or even eliminate risk factors for workplace violence. You can accomplish this by being aware of your surroundings and environment, where applicable, following or assisting to create specific safety procedures for tasks such as working alone, handling cash, working off-board property, working with students with violent or high-risk behaviors, or working late at night or during early morning hours. Participating in and using any safety training you receive, such as de-escalation CPI training. Reporting incidents of conflict to your supervisor and seek resolutions so situations do not escalate to become violent or harassing. In the event that workplace violence occurs or is likely to occur, immediate assistance should be summoned using the PA system or another available communication method such as a walkie-talkie, telephone, colleague, or cell phone. Critical judgment must be exercised, and police should be contacted if necessary. Be sure to notify your immediate supervisor of the workplace violence incident. Subsequently, first aid or medical treatment should be sought for any injured victims. If workers seek health care or require time off because of physical or mental stress, the supervisor will need to complete an incident report. An incident or complaint of workplace violence from any source must be reported by employees electronically using the Employee Workplace Violence Incident Report, which can be accessed from the Board's Incident Reporting landing page. Please note that incidents or threats of workplace violence directed at an employee by a student are also subject to the protocols required under Safe Schools Policy No. 48. If the incident is one for which suspension or expulsion should be considered, a Safe Schools Incident Report must also be completed. Supervisors are required to investigate all violent incidents. However, if the supervisor is alleged to be involved in the incident or is named as an assailant, the concern needs to be reported to the next level of management above the supervisor, who will lead the investigation. All parties, including witnesses, must cooperate with the investigator. Depending on the nature of the complaint, a number of parties can be involved in the investigation. The employees' federation, association, or union representative can be involved or consulted at the employee's request. Upon completion of the investigation, employees will receive a copy of the completed report via email notification. You have the right to refuse to work if you believe workplace violence is likely to endanger you. In this case, the normal process of a work refusal as outlined in the Occupational Health and Safety Act is followed. Employees must report work refusals to their supervisor, who will investigate immediately. The board's health and safety team, the school site designated worker, the multi-site joint health and safety committee member, and your union or association may also be involved in the investigation. During the investigation, you will be required to stay in a safe place and be available for questioning. If the situation is not resolved, the Ministry of Labor will be called in to investigate and make a decision. Some workers, such as nurses, firefighters, and police officers, cannot refuse work if the danger is a normal part of their job or if refusing work would put someone else in danger. Similarly, teachers have a limited right to refuse work. While the Occupational Health and Safety Act grants teachers the right to refuse unsafe work, Regulation 857, Teachers, requires a teacher to ensure the health and safety of a pupil is not in imminent jeopardy prior to enacting a work refusal. Now, let's talk about workplace harassment. Workplace harassment is defined in the Occupational Health and Safety Act as engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. A vexatious comment is one that is made without reasonable cause or excuse. These comments or behaviors usually happen more than once, whether during a short period of time, such as over the course of one day, or more likely over a longer period of time, such as months or years. Harassment also includes discrimination on the basis of one's ancestry, sex, religion, etc., as prohibited by the Ontario Human Rights Code. Can you think of some examples of harassment? Sexual harassment is defined as engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome, or making a sexual solicitation or advance, where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. In 2015, the Act was updated to specify what a workplace harassment program must include. Our PDSB Workplace Harassment Operating Procedure includes measures to report workplace harassment to someone other than the employer or supervisor if that person is the respondent. Information on how incidents and complaints will be investigated and dealt with. That information related to an incident or complaint of workplace harassment will not be disclosed except as required to complete the investigation, and ensure that complainant and the respondent are informed in writing of the results of the investigation and any corrective action that follows. Workplace harassment includes psychological harassment or personal harassment and may include behaviors such as unwelcome words or actions that are known to be offensive, embarrassing, humiliating, or demeaning to a worker or groups of workers, behavior that intimidates or isolates against a worker or groups of workers, bullying, intimidating, or offensive jokes or innuendos, display or circulating offensive pictures or materials, or offensive or intimidating phone calls or emails or social media postings. Repeated words or actions or a pattern of behaviors against a worker or groups of workers in the workplace that are unwelcome. Asking for sex in exchange for a benefit or a favor. Making unnecessary physical contact, including unwanted touching. It is also important to remember what workplace harassment is not. Workplace harassment does not typically include performance management, operational directives, job assignments, inadvertent management errors, a single incident, any other reasonable action taken by an employer or supervisor relating to the management of employees or the workplace. All individuals who believe that they have been subjected to, witnessed, or suspect workplace harassment have the right to report the incident. The first step is to attempt an informal resolution in a mutually respectful manner. This method involves informing the individual that his or her behavior is unwelcome and must stop immediately. Many disputes can be resolved quickly and effectively by using this approach. At the request of the employee, the supervisor can intervene on behalf of the complainant and communicate the expectation for appropriate behavior. The goal is to obtain a commitment for the unacceptable behavior to stop. Where disputes are resolved informally, there will be no formal reports about the disputes. Every effort will be made to protect the privacy of individuals. However, it should be noted that when the complainant and respondent are both teachers, the complainant must meet the reporting obligations of Section 18(1)(b) of the regulation made under the Teaching Profession Act. When the informal resolution process is inappropriate or ineffective in addressing a workplace harassment complaint, a formal resolution process must occur. Individuals who believe that they have been subjected to, witnessed, or suspect workplace harassment can initiate the formal resolution process by reporting the concern to their immediate supervisor and/or by completing the workplace harassment report form. Completed workplace harassment reports need to be submitted to the immediate supervisor with a copy provided to the Labor Relations Team and Human Resources. If the supervisor is the party named in the complaint, the form needs to go to the supervisor's manager. It should be noted that complaints should be submitted no later than 1 year after an incident of workplace harassment. Complaints of workplace harassment are investigated in a manner that is appropriate in the circumstances. An investigator will be assigned by the board and may include a supervisor, superintendent, manager, or third party. It should be noted that allegations related to discrimination on the basis of a ground prohibited by the Ontario Human Rights Code will be addressed through Human Rights Policy Number 51 and the appropriate procedure. As part of the formal resolution process, individuals will be told in a timely manner that they are the subject of a complaint, who the complaint is from, and what the allegations are. Formal complaints require interviews with the complainant, respondent, and any witnesses. A written summary of the findings is given to the complainant and respondent. Let's review reporting processes for workplace violence and harassment. Workplace violence reports need to be reported using the online Employee Workplace Violent Incident Report found on the board's intranet site. If the violent incident involves student action where disciplinary action should be considered, Safe Schools Policy Number 48 must also be followed. In the case of workplace harassment, in situations where formal resolution is being sought, the workplace harassment form should be completed. If the harassment is classified as discrimination under the Human Rights Code, Human Rights Policy Number 51 will be followed rather than the board's workplace harassment operating procedure. In circumstances where a worker seeks medical treatment and/or takes time off work due to physical or psychology injuries, the board's incident report form needs to be completed by the worker's supervisor, in addition to the reporting forms for workplace violence or workplace harassment. This concludes our training. Here are some internal resources which you may want to review for further information. Here is a listing of external resources that can be found at the Ministry of Labour website. The link to Ontario's Health and Safety Associations is also provided. Thank you for completing Workplace Violence and Harassment e-module.